Today's Imprint Weekly podcast is brought to you by Accenture. Change is afoot in child welfare. Change that means agencies focus on results for children and keep far more of them safe at home with their own families. Accenture's child welfare team is leading the way in the effort to ensure technology does its part in that success story. Accenture offers cutting-edge case management tools that ensure agencies can see insights that drive decision-making and caseworkers have information they need at their fingertips. Together, these tools help agencies stay laser-focused, reinventing child welfare into a source of strength for families when they need it. For more information, visit www.accenture.com/child-welfare.
Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of the Imprint, which is a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. On this week's podcast, NPR investigative reporter Joe Shapiro joins us to talk about his coverage of child welfare systems charging parents for the cost of foster care, a practice born of a change in federal law in the 1980s that expanded with accompanying state laws and policies since that time. Before we get to our interview with Joe, let's do a few headlines for the week, and we're going to start in Washington State. Most states have some guaranteed right to counsel for parents who are accused of abuse or neglect, but often that counsel is guaranteed after the point that a child has been removed into foster care, or in some states isn't guaranteed until a termination of parental rights is on the table. So generally what that means is that the first time a parent has been offered, free legal counsel or any legal counsel by a court or by a child welfare agency, they have already had their child removed and placed into foster care. Now, this year, Washington state legislators could approve what I think might be the first law to guarantee legal counsel for some parents before that point of removal. I'm going to link to reporter Jeremy Loudenbeck's great coverage of this new bill in the Imprint, but here's the gist. If it passed, this bill would mandate the offer of a lawyer to any parent that was approached by Child Protective Services about what's called as a voluntary placement agreement, which is a more formal term for what some would refer to, and that we've talked about quite a bit on this podcast, as hidden foster care. Generally defined as the shift of physical custody of a child without the formal change of legal custody that comes with going to court and having a child removed into the formal foster care system. So by way of example here, if a person was approached by CPS, the agency did not feel that a child was safe there, they may try to get the parent to agree to an arrangement where the child went to Aunt Jenny's to stay while the parent was working on an improvement plan of some kind. That's not done with an agency going to court to seek a judge's approval to make that a movement. It's agreed to voluntarily by the parent. And so the voluntariness is what's been called into question in recent years by lots of legal and parent advocates who have some concerns about exactly how voluntary the nature of that is. I would sort of summarize the legal concern around hidden foster care as a concept with there's obviously the implication that CPS, if a parent was not to agree to a voluntary agreement, would go back to court and seek that formal removal into foster care. So how voluntary really is it if what you're saying is, hey, you could agree today to send little Tommy to Aunt Jenny's, or we'll be back with a formal removal signed off on by the courts. And so that is what this bill really tries to target at, is not to guarantee legal counsel for any parent who is being investigated writ large across the state and the system in Washington. It's for situations where, child welfare has proposed the solution of a voluntary place agreement, guaranteeing counsel to people who are thinking through that. The idea being that counsel might be able to look at the set of circumstances and be able to advise a parent on basically saying, I don't think there's any grounds for removal of any kind here. So you could tell them to leave if you want, or giving them advice around the terms of the agreement. Now, Washington's Child Welfare Agency, the Department of Children, Youth, and Families, didn't endorse the bill as it was introduced. They were represented at a hearing about this bill last week and said it was too vague, but did say that it was very supportive of getting counsel to parents earlier. So we'll see if there's further iterations of this bill that maybe kind of specify a little bit more acutely around this voluntary placement agreement issue in a way where the department might support it. I think if the department supported it, that would mean the governor would sign it, and we'll continue to keep our eye on it and report further. Last week, we mentioned on the podcast that 3 states are already considering the adoption of a state version of the Indian Child Welfare Act. That is the law that was passed in the 1970s to protect Native American families in this country at a time when up to, a third of children were being separated from their indigenous parents. So those 3 states were Nevada, North Dakota, and Wyoming. There are already 11 other states with ICWA laws already. And anybody who follows this podcast and what we've been covering at the Imprint knows the reason that this is all coming to fore right now is because the Supreme Court heard arguments in a case called Brackeen v. Holland, which, depending on how the Supreme Court decides on it, could essentially end the Indian Child Welfare Act, or ICWA, as we know it, or strip certain parts out of it, or leave it standing. Hard to tell yet, and we probably won't know until the late summer. So Nevada, North Dakota, and Wyoming are the states that have things moving right now. Like I said, there are 11 states that already have done this. You can add one more potentially to the list for this year, and that is Utah, which is home to 5 federally recognized tribes and 8 tribes in total. According to the local Deseret News, a bill was introduced to codify ICWA in state law, but then was held by the committee, which means, and I'm quoting here from the Deseret News story, a hold blocks a bill from advancing to a vote on the House floor, although it may be reconsidered at a later point. And I know that there is some campaign afoot to really push for ICWA as a state law in Utah, so we'll keep tabs on that as well. Here's a comment from the story in the Deseret News that kind of shows a challenge, even with the existing protections in the federal version of ICWA that was passed in the 70s. So there's a piece from that story. Representative Nelson Abbott expressed concern about how parts of the bill are written, specifically relating to definitions of extended family members and standards for removal that would defer to tribal laws and customs or federal law. Maybe with the 8 tribes through negotiation, we could get to a point where we can specify that and put that in the code so that a judge isn't forced to call in expert witnesses to testify about the culture of a given tribe to determine what an extended family means, Abbott said. And what really jumped out to me about that was that these judges are already supposed to be enforcing those protections. We currently have a federal law that mandates the implementation of ICWA, which includes the requirement that expert witnesses testify about the culture of a given tribe and testify about extended family in cases. So, worrying about whether a state ICWA law would confuse judges is a little bit of a giveaway about one of the problems we have now, which is that we have ICWA as a federal law across this country, and all these state judges are already supposed to be understanding it to the point that they can actually enforce it. And while we are in a critical mood as far as legislators go, and I'm switching gears here to a totally different story, here's a comment that I caught made by Tennessee State Senator Farrell Hale, I'm hoping I'm getting her name right there, who is leading an effort to pass 20 different bills aimed at making adoption easier in the state of Tennessee. And the reason behind this push is the state's recent trigger law that has banned abortion completely. So here is what Hale told reporter Ben Hall. I think we are going to have more children in care, she's referring to foster care, and if we wait for those children to come into care, we are going to be even further behind. Another supporter of the bill, State Representative Jeremy Faison, said, It's beyond time for us to say we are pro-life, not just before birth, but after birth. And I'm just going to throw the penalty flag, so to speak, on this for two reasons. First is anticipating a rise in foster care as a result of an abortion ban implies that just because a parent or parents don't want to have a child makes them likely to abuse or neglect the child they will have. And I feel like I'm editorializing here, but I promise you, people have had kids every day that don't necessarily feel prepared to or want to, and they don't take that out on the kids via abuse and neglect. I don't necessarily think this is a slam dunk, but this would be a more logical leap to think that private adoptions would increase, presumably because more people will be in a position where they don't want to raise a child and seek a private arrangement. Nobody who doesn't want a child just puts them directly into foster care as newborns. And on private adoptions, I'm sure the process could be made easier in Tennessee or in any other state, but that's not going to be necessary in this country to make newborns more, so to speak, attractive to private adopters. There are already more adoptive parental candidates in the pipeline in this country than there are newborns for them to theoretically raise. But going back to the spirit of this package of bills and making adoptions out of foster care easier, like, why not put that effort into supporting the reluctant new parents that the state is about to be home to? Because that's a direct and immediate proposition, like making it easier to raise a child for people who might be scared to do so or worry about the financial means to do so, as compared to greasing the skids from foster care to adoption, which at best is a second order effect solution. Last thing for this week, we told you back in October that the Biden administration put out the blueprint for an AI Bill of Rights that's making automated systems work for the American people. It outlines 5 common sense protections for using algorithms and predictive analytics and automated data with consequential impacts on people. The report states too often these tools are used to limit our opportunities and prevent our access to critical resources or services. In child welfare, the concern about the use of predictive tools is actually the opposite. Not that it would exclude people, but it's that it would lead to disproportionate inclusion in the system, particularly for Black families. At least 11 states have child welfare agencies within them that are using algorithms to predict which children are at higher risk of maltreatment by their parents, or to triage cases for review, or just to improve their operations. Now it appears that the Biden administration's Justice Department might have taken an interest in scrutinizing further the biggest experiment with predictive tools in child welfare, and that is the Allegheny Family Screening Tool, AFST. To the nerdy wonks who study this all the time, AFST is operating in Allegheny County, which is home to Pittsburgh. And according to the Associated Press, which has published quite a few stories about the county and its use of this tool, the Department of Justice has been scrutinizing it. There's no mention of an actual investigation, and the Justice Department had no comment on this story. Allegheny did not have a comment on the story. The Associated Press is basing their assertion that they are scrutinizing the tool on 3 anonymous sources, 2 who said that civil rights attorneys at the Justice Department urged them to file formal complaints about the tool, and then another anonymous source who said those same attorneys had a long conversation with them about concerns around the tool and potential disparate incomes from its use. Now, one interesting wrinkle in both cases, right? These 2 anonymous sources who said attorneys urged them to file complaints, and then the one who said they were contacted by Justice to talk about the tool. The attorneys were focused on the disparate outcomes and bias in the tool as it applied to disabled people and families with mental health issues present in the home. And that's very different than the concerns that were really highlighted in the AP story and a lot of the heat in general around the use of AI and predictive tools, which is focused on people's fears that they could exacerbate racial disproportionality and racial biases in child welfare. So the sort of indication that what the Justice Department is looking at is how it affects or impacts disproportionately on disabled adults is interesting. I don't want to tea leaf read too much on that, but I guess one thing that comes to mind for me is that they may have obtained data that very explicitly shows a current or an ongoing bias against disabled people in Allegheny County, where some of the concerns around the racial disproportionality impacts is theoretical to some extent. The other thing that came to mind was maybe that it's a little easier for them as civil rights attorneys to pursue an investigation or a challenge under the tenets of the Americans with Disabilities Act of the ADA. Anyway, that is complete speculation. And again, this is not an investigation that's been confirmed or a scrutiny that's been confirmed by the Justice Department yet. So we'll continue to kind of monitor and update on that story as it comes. All right, when we come back, our interview with NPR's Joe Shapiro.
Are you a professional in the field of child welfare, juvenile justice, or other family and youth services? Subscribe today to Youth Services Insider, the imprint's exclusive section on all the insider news you need to stay in the know. Funding opportunities, major federal and state policy shifts, interviews with key leaders in the field. It's all available only for our Youth Services Insider subscribers. Sign up for a monthly or yearly subscription today by visiting imprintnews.org/subscribe. Our podcast listeners get 10% off their subscription by entering the promo code podcast10. That's imprintnews.org/subscribe and get 10% off your subscription by entering the promo code podcast10 today.
We are joined today by NPR investigative reporter Joe Shapiro, who has spent the past 2 years reporting with colleagues on two ways in which child welfare systems can bill the families that it serves. We're going to focus mostly on one of those paths today, which is collecting from parents for the cost of their child's foster care. So, Joe, thanks for joining us on the Imprint Weekly Podcast.
Thanks, John. I appreciate the work that you and the Imprint do.
And we appreciate yours. So before we get into the weighty topics of the day, you got to tell these folks a little something about you. You got to give me at least one of these, your favorite TV show, movie, musical group, book, or sports team. Joe Shapiro, what do you got?
Music. I'm a big fan of Prince. The concert I've been finding things online of old concerts and music, and a lot of that got me through the pandemic.
Yeah,
I'm a big baseball fan of the Washington Nationals. Last year, the worst team in baseball, but in 2019, the winner of the World Series. I've been a season ticket holder since Washington got its team in 2005.
Okay, let's start with the federal law that kind of got the ball rolling on the issues you reported on here in these stories, which, by the way, I will link for listeners who want to read a lot of what Joe's been writing about that we're going to talk about today. It'll be in the show notes for this episode. So this law occurs in 1984. It's a bipartisan bill. It gets signed by Reagan, and it's not a child welfare bill. You know, it's an overall goal of this legislation was to put more teeth behind child support payments, because the estimates at the time, I guess, were, that about half of spouses who were supposed to be getting child support were not getting it. So that was the intent of the law, but it includes some new rules around foster care. Can you kind of explain to listeners what those rules were?
So the idea was that people who get welfare should share some of the responsibility of getting this assistance from government. And Ronald Reagan signs this bill, and he says that the failure of some parents to financially support their children is a blemish on America. And you're right, it's concerned about child support overall, but it included this provision that said that when parents get assistance for foster care, that states should try to recoup some of that money to send a bill to the parents and then return part of this money to the federal government, to reimburse the federal government for the money that it was putting forward for the cost of foster care. And there's an out. There's a clause in that law that says bill the parents when it's appropriate, but it doesn't say much about what that means. But presumably that means if you're trying to reunite parents with their children, and these are poor children because they're eligible for the Title IV money, that you would not add the burden of the cost of foster care. That we know would delay the time that it takes to reunite families. So many child welfare agencies take that clause when it's appropriate and decide not to bill families, but every state has been billing families. In 2020, fiscal year 2020, there was actually a rise in the amount of money that was collected because child welfare agencies went after the stimulus checks, the pandemic stimulus checks.
Wow.
And they returned, I think it was $113 million to the federal government. That's about half of what was collected. And then last year, in the last fiscal year, 2021, they collected $97 million that was returned to the feds. But so they're even taking stimulus checks. So every state has been doing this. And child welfare agencies say, look, we're expected to do this. It's in the law. And they feel they have an obligation to do it. And then what was interesting was that after our story came out in December of 2021, the Children's Bureau and the Office for Child Support Enforcement at the Department of Health and Human Services issued this new guidance.
Yeah, I want to
non-binding recommendation telling states, hey, that this doesn't make sense. But anyway, so I'm jumping ahead. I'm jumping ahead of you, right? see, I'm more used to asking questions.
I know.
All right.
So we would definitely get to that because I did want to ask you about their policy and what it does and doesn't accomplish. But let's go back to states for a minute because this is a federal rule that's really kind of precisely about child support in its start. The weird thing, and what you guys have found through your reporting and surveying these states, is that all of them, or maybe almost all of them, have added to this federal thing by having their own policies about collecting, which I would say it's like not surprising that would be the case because federal reimbursement for foster care only covers a certain number of people. It would honestly, if you did think this was a good policy or what you wanted to be doing, it would be weird to not collect from the other parents too. Like that would be very strange, right? But you did find that it was all the states.
Right. It was all the same. And it's sort of an equity issue, right? If you're taking from poor parents, shouldn't you be taking from richer parents? I'm not sure we counted up exactly how many added laws of their own, but many did to collect from all parents.
Yeah.
And every state gave you this money. We looked at the statistics from the Office for Child Support Enforcement. There's actually one state on there, now I'm blanking on which state it is, that shows that it does not collect. But when we called that state, they said, no, that's a mistake. We do collect.
We do collect. Okay.
So every state does. Yeah. Now, some states are trying to stop, and some states told us that they use their discretion. We did our own 50-state FOIA. We called states. We asked them to double check the numbers. We asked them how much they collect. And we did find in that 3 states told us, look, we try to do this very sparingly. And you can see it in different states collected at different rates. But I think, I don't have the numbers in front of me, but states collect at different rates, but some collect in a large percentage of these cases.
Yeah. I'm curious what the state level payment regimes look like. And I guess why I asked that is because, when you're talking about child support and trying to capture child support, that money is, I'm assuming, maybe I'm wrong here, that's the money that's never going to make it to the parent that was going to get it. So instead it gets rerouted or garnished or whatever. But, I remember in reading the first of your stories on this, you tell the story of Daisy Holman. I hope I'm getting her last name.
Yes, that's right.
In Minnesota, who, the way I read it was she gets her children back after they'd been in foster care, and almost it seemed like she got the kids and a bill for $19,000 in foster care costs. So I'm just curious, is that in your reporting, is that typically how parents do this, or are they notified? Do they get monthly invoices, or are they just hit with a bill they didn't know was coming from states?
We found a lot of cases where parents were completely surprised. They didn't know this bill was coming. Sometimes it comes while the children are in foster care, or it comes later, and it sticks with them for years. And that first story, we talked about a woman in Orange County, California, where the Office of Child Support did their own survey and showed how they lose money trying to go after these parents. They spend more money trying to collect money than they actually collect. But they had one woman who had been, she'd been paying off for 30 years. And she was a woman who'd been the victim of domestic violence, and she lost her children because her spouse was violent. She lost her children. parental rights were terminated, and then she was stuck with a bill that she tried to pay off over 30 years. So when do people find out? It's not unusual for what happened to Daisy Holman that they find out later. The kids come home, parents trying to follow the steps that the court has laid out. They're trying to create a successful home. They've got a lot of expenses. Often we found time and time again that part of the instructions are if you want your kids back, you have to find better, stable, safer housing, which means saving up money, renting a bigger place, a better place. And these people are struggling. And then you get this bill. Daisy Holman got this bill for, as you said, $19,530.07. Although when she asked the county to itemize, what that was, they couldn't or they wouldn't. But she got this $19,500 bill. That was basically how much money she made in an entire year. She worked as a landscaper in Minnesota, seasonal work, and she just made a few $1,000s more than that. And so she got this bill. She had rented a larger apartment, which she was required to do to get her 3 kids back. The fact that she owed this money went on her credit report, which made it harder for her to rent a nicer house. They garnished her stimulus check. She told me the story how she had a car that was about 18 years old, an old Pontiac with 250,000 miles on it, and she did all the repairs, or the minor repairs, and changed the oil. So the point was that here she was trying to be a good mom, get her kids back. Now she was faced with dealing with this huge bill that was a huge burden for her, and she was afraid. She didn't know if she would lose her kids because she couldn't pay the bill. And a lot of what she was paying, it was the stuff the checks, the things that were being garnished, the things that were being taken from her. I guess I can't remember if she was paying off regularly herself, but it was a big burden on her. And
I'll tell you, I think why this was really eye-opening for me was because before I read your reporting on it, in my head, what I envisioned, because I was aware this is something that Senator Ron Wyden had kind of brought up in hearings.
Right.
People in child welfare knew about it. You guys, I think, put a really good human face and reality to it. But I guess in my mind, what I was thinking was happening was, a youth or children are taken into foster care. All of a sudden, a mom who maybe was getting a steady amount of child support, all of a sudden it goes away. So, right, that creates its challenges, certainly. But at the very least, that's happening. That's
Right.
happening too, because it's where is this money go that I used to be able to rely on? And you find out that's very different to me than being ambushed by this absurdly high bill,
Right.
which then all of a sudden you're facing a loss of your credit power,
Right.
bankruptcy, all that.
Right. And by the way, and Daisy Holman's offense was, fairly minor. She was charged with neglecting her children. She didn't have a lot of money. She was divorced. She left her husband. I think there were issues of drug abuse. She left her husband, and she was homeless. And she ended up moving into a trailer with a friend. And he was apparently dealing drugs. There was a drug raid on the house. And nobody found drugs on, it wasn't that anyone found drugs on Daisy Holman in the room where she lived with her children in this trailer. None of the drug paraphernalia was found, none of the drugs, but she was charged with leaving her kids in this dangerous household.
Sure. Right.
So it's the type of thing that it was a poor woman struggling sort of to do her best, and making some mistakes, but it wasn't, but it was a loving household, and she wanted support to help her kids, to be with her kids, to have her family. She was trying to make it, and she has, by the way, been successful since. So yeah, it hurts these families. In this recent story I did in North Carolina, I met Courtney and Jeremy Johnson. Again, they were a very poor family struggling to make it, living paycheck to paycheck, a house with a lot of love, and their twin sons were put into foster care after some complaints that they weren't being supervised well enough. And anyway, the kids go into foster care, and then they get a bill for $17,000. They're living from paycheck to paycheck. It's huge. They had no idea. And they had not been billed before. Child support enforcement, after the 3 years of the kids in and out of foster care, gives them a bill. And it's a complete surprise to them. Suddenly they have they're charged $17,000. And in North Carolina, the issue there is that state, if you don't pay, they can terminate your parental rights.
Yeah,
And
so let me ask you about that
yeah,
actually, and kind of set that up for people because
yeah,
in general, there's kind of two consequences, collateral consequences from these payment regimes that you single out. One of them is a little more subtle, and it's from research. You guys found this, and I'm glad you included it because I was unaware. But Marika Kancian, I think is her name.
yeah. Conchana, I think.
Conchane,
Yeah,
okay.
Conchana. Mm-hmm.
Created this estimate that for every $100 of charges to parents, that is associated with an increase of 7 months in foster care.
Yeah.
So that's a real to the extent that is true in across the country, wherever that type of relationship would occur, that's an enormous increase in the time to reunification, which can cause all kinds of problems, including that courts tend to weigh quite heavily in some places on the best interest of the child, and some judges really rely on like the child's sense of time to make their call. So if you an extra 7 months with some foster parent or in a pre-adoptive home or whatever, that is going to weigh very much on your case. But the one that you're talking about is even more significant, which is this issue of termination of parental rights. So courts, thousands of parents get their rights terminated every year, and that's a process that's like supposed to be either because something so egregious happened that it goes pretty quickly, or because reunification just hasn't been achieved in a certain amount of time. The federal standards, 15 months out of 22. Some states really stick to that, some do differently. But, I think the most glaring thing from your guys' reporting was unearthing that there are actually states where just this debt owed in and of itself could be grounds for termination, which really floored me. So can you talk a little bit about like how many states and how does that look on paper?
So I went to the codes for the termination of parental rights in all 50 states and I looked at the laws to see if they had specific language that mentioned failure to pay child support. And 12 states, including North Carolina, have this written in their termination of parental rights guidelines. And I've had other lawyers write me and say, it happens in our state too, even though we're not one of those 12 states. Public defender of Louisiana wrote and said this is common. I've heard about it in Tennessee, where they use other laws to do this. But 12 states specifically have it in their termination of parental right law. And those 12 states are listed in our story. So, and we sent early on, we asked, sent something on a listserv of child welfare lawyers to see if it happens in their state. And we didn't get a lot of cases back, but we got a lot in North Carolina, which is why I focused there.
Right. Yeah.
And in North Carolina, so I went back, I read over 200 cases of TPR cases in North Carolina that have gone through the two appeals courts there over the last 2 years, 200 cases. And in 30% of the cases, there's some reference to this ground of failure to pay child support as a reason to terminate parental rights. 30% of those cases, it comes up. In a small number, I found a dozen cases over the 2 years. That was the only ground cited. So in those other cases, often these are the cases that when they get to the courts for the termination of parental rights, often there is some really bad history. There is abuse, continued unaddressed neglect, abandonment. There are really serious issues, and the failure to pay child support is sort of a minor one. It might get dropped, and they go with the other ones. But there are these other cases, these sort of the gray areas where it wasn't so clear that the court could use abandonment or unaddressed neglect or abuse. And they fell on this issue of, you didn't pay the child support. we're going to terminate your
So
parental rights forever.
I have one question and then a comment on that.
Yep.
The question is this: when you say the standard of failure to pay child support, in all of these cases, is that referring to a failure to pay an agency the child
Yes.
support? Okay,
I'm
so it's not the
I'm
case
sorry.
where maybe, like, I'm
Not,
thinking like a dad who could have their rights terminated
yeah.
because they aren't paying child support to a
I'm,
mom or
yeah,
something like
I'm
that.
sorry. I use child support, right? The way they
Yeah,
use it in the law, but that's correct. These are
pay the
the
state.
12 cases I found in North Carolina were cases where parents failed to pay the bill
Yeah.
for foster care.
Yeah. So
And
what
yeah.
I was going to say, my comment is actually, I kind of don't think that's a small number at all. 6%,
Oh, right.
6% of those appeals you reviewed,
Yeah,
which
yeah.
props to you for reviewing 200 appeals. That must have been a fun
Right.
2 months of reading. Good thing you have glasses, but,
Those days.
yeah, but, that is a lot. I mean, 12 people who
Yeah.
lost
Right.
their parental rights for no reason to do with the effort, what they did or didn't do to reunify, efforts they made or anything like that. I really came away from that part of your story thinking like, that's, I wonder if somebody has considered class action litigation to challenge whether that premise is acceptable constitutionally, to hold a parent's rights ransom for just
Right.
that issue. You know what I mean? It's, like you said, if other things are in there conflating it, sure. I mean, that's a battle you talk about in policy. But yeah, I don't know if is that constitutional. Like, have any of the
Right.
lawyers you talked to raised that?
And they have, and let
Yeah,
me mention that, right, 12 cases, that's a lot. And remember, these are the cases of the Wendy Sotolongo, who runs the group of parent defenders for the state of North Carolina, said, look, this is an easy way out for judges. These were cases where they didn't want to look at the harder issues, which weren't so clear about abuse or not following through. And so this is she said, this is an easy way out, right? And so, yes, so she questions it. And then a lot of great work in North Carolina is being done by a lawyer named Benjamin Cull. And he was the attorney for two of the families that I followed, the Johnsons and the Cunninghams. And he has filed a petition to be heard at the U.S. Supreme Court of cert. And, the Supreme Court gets something like 70,000 of these cases a year and takes 60, or it is some tiny number. And so he's asked to be heard on this issue. He's challenging it. He's challenged it in the state Supreme Court in North Carolina, and he's was denied. The state Supreme Court in North Carolina did something very odd, and that Ben Cull was challenging. In a lot of these cases in North Carolina, as we said before, the parents weren't notified before the termination of parental rights. They weren't told. They were never given a bill. So these parents say, well, wait, if I wasn't given a bill, how could I possibly have paid this? There's no way. I had no actual way to pay it. First of all, I didn't know. And even if you say I should have known, there was nothing set up for me to pay. That I can't just give money to a social worker. And the state Supreme Court in a 2020 case, and by the way, I found other cases beyond my 12 that were older than 2 years, but in 2020, in a case against a woman named Sarah Enos, who's a woman from the Marshall Islands who speaks very limited English, and says that she was never told that she owed this money. The state Supreme Court said, you can't hide behind the cloak of ignorance. You can't say that you didn't know, that parents have an inherent obligation to pay for the support of their children, and you should have done so. So
that is ludicrous.
It's ludicrous, right? And so we found lots of cases. We found people in prison who were penalized because they didn't set aside money while they're in prison. There was Sarah Enos's case who said she didn't know. Brandon and Sylvia Cunningham, who I feature in my long story recently, they were never told that they owed the money. The Johnson family child welfare agency in their county in North Carolina had said in a report to the court in a line or two that they were considering charging them for the cost of the foster care. But then it wasn't for another 2 years that the county's Office of Child Support Enforcement issued a a bill. And by that time, the county had already started the termination proceedings on the grounds that the Johnsons had not paid this bill. So the Johnsons didn't even know that they had this bill. And then when they finally got the bill, it was for $17,000. This couple going from paycheck to paycheck. There was another case that a lawyer told me about who represented a young woman who was 15, got pregnant, was in foster care, had a child when she was 15, and then when she was about to leave foster care, the county took her child from her on the grounds that she had not paid the cost of foster care, even though both she and the baby were in foster care themselves. It was absurd. It was saying, you didn't pay for foster care. Well, I'm in foster care. I don't, you're paying, you're not deducting anything from what you're paying for me, but they use that as a reason to terminate her rights to her child.
Before I was adopted, I felt like my life was already over.
My biggest fear was that I would age out and not know how to be sufficient on my own.
At a certain age, they don't want you, you're troubled and stuff.
The clock is ticking for the more than 125,000 kids waiting to be adopted from foster care. Help the Dave Thomas Foundation for Adoption prevent them from aging out without a permanent family. Learn more at davethomasfoundation.org.
And if you're sitting here listening to this conversation and thinking, maybe there should be accountability, maybe a parent who is irresponsible with their child should be paying. Here's another crazy turn to consider. We are not making money on this, right? All the state by state research that exists suggests that the amount collected through this process, it looked like for most states about half of what it costs to collect it.
Right.
Is that right?
Right. This is from my story in December of 2021. I came across, actually, that's how we got started with this story. And I was doing this with the first story with Teresa Wiltz, now a top editor at Politico. And then she worked for Pew Stateline and covered child welfare. And she'd come across this. I come across it I'd read Daniel Hatcher's book, The Poverty Industry. And so we both had an interest in this. So it was Teresa who got a report that was written in Minnesota about this issue. And in Minnesota, state officials were looking at this because a woman named Trish Skophammer in Ramsey County, which is St. Paul, in the Office of Child Support Enforcement, had done her doctoral dissertation and knew about this issue. She was concerned about it. And her doctoral dissertation was looking at how much was collected in Minnesota. And basically what happens is that the Office of Child Support Enforcement in all these places, they lose money because, as you know, these parents are poor. They move around. They're hard to find. It's not like the more typical people that they're trying to get child support from, right? Where there's been a court order between, when the parents divorce and that sort of thing. These parents who owe the money for the cost of the foster care bill, they're very poor. As Trish Skophammer found that a large percentage of them had income of $10,000 or less. They were extremely poor. And they moved around, they're hard to find, and her office was spending more money than it collected. And she was collecting something like 25 to 40 cents for every dollar that they spent. She spoke at a conference, and a guy named Stephen Eldred, who ran the Child Support Enforcement Office in Orange County, California, he was floored by what she said. And he said, I wonder if we can find that here. So he duplicated her study and found the same thing in almost the exact same numbers in Orange County. They were losing a lot of money going after these parents who hadn't paid the bill for foster care. Washington State did something similar. It's all the same, that for every dollar they collect 24 to 41 cents for every dollar they spend. So it makes no sense. So the states are losing money. So why then do we keep doing this? Because is who loses the money? It's the Office of Child Support Enforcement. They lose money going after these parents, but they collect a small amount of money and then give it to the Child Welfare Agency, right? Which then returns half of it to the federal government. So it's as Stephen Eldridge said to me, it's found money for the Child Welfare Agency. They didn't spend anything, and they get, even though it's small, even though this other state agency lost money trying to get it, for eventually it ends up at a place where it's extra money. It's found money. So there's not much incentive to stop doing.
Going back to real quick to the 12 states that have, the failure to pay as a sole driver of TPRs or termination of parental rights: Georgia, Kansas, Kentucky, Massachusetts, Minnesota, Nebraska, North Carolina, Oklahoma, Oregon, Rhode Island, Vermont, and Wisconsin. I stared at that list for like 5 minutes trying to figure out if there was any sort of pattern. That's a pretty random list of states. That's a real hodgepodge of East and West Coast, Southern states, Northern states. There's no real rhyme or reason to who decided to get that severe on the TPR consequences. I guess there's a lot of New England states, half of New England. So
I don't know how it got written into those state laws about termination of parental rights. But I don't know. I said in my story that I don't know how often other states use it. I couldn't find. I said it was rare in those other states. So as I said, I get somebody from Louisiana, which wasn't on that told me that it's that he sees it a lot. But I did find it. But I focused on North Carolina because I did find it happens a lot there. I can point to cases. I'd like to hear about more cases in those 12 states or any other state. If people listen to this and they know of this happening, I'd like to have a better sense of how often this happens. But those 12 states have it in their code, and it looks like other states do it as well. But I couldn't quite tell how frequently it happens.
Sure.
In North Carolina, I was able to look at those 200 TPR cases over 2 years, and as and found 30% it comes up.
You have reported on lots of other parts of the social services sector in your career, not just child welfare. This whole concept of clawing back money to pay for the feds or to restore to a certain agency, how commonplace is it? I mean, is this, for somebody that's inside and really focused on the child welfare stuff, it seems like unique, but is it? I mean, or is this something that happens across the spectrum of services?
So that's a good question. Child welfare is not I don't have a specialty in that. I've covered social policy issues for about 35 years. So, and I've covered child welfare issues going back to the 1980s, but I cover a lot of things. I have a broad portfolio on the investigations unit at NPR. So how broad is it? It's broad. Here's how I got it. Here's what interested me in this. I did a series in 2014 about how we do something similar in the criminal justice system, how it's a system that we don't fund, states don't fund enough with taxpayer dollars as the criminal justice system expanded. So states found ways to make revenues by charging fines and fees to the people who go through the system. Is very similar to this child welfare situation. So the people who go to court get charged all sorts of fines and fees. Everything from, I thought a public defender was free. You have a right to a public defender, but sometimes they charge you. In some states, if you lose, you get charged. They can charge you a fee for every day you spend in jail. You get charged for, if a warrant is served, you can get charged for all sorts of things when you go through the court system. And again, these are the poorest people. The people couldn't afford them. I did a story back then about a man. He swiped a can of beer from a convenience store, a beer that was worth $1.20, and he ended up in jail for a year because he got caught. And he was charged all sorts of court fines. He was put on he didn't go to jail. They put an ankle monitor, an ankle bracelet on him, but that cost, it was something like $400 a month. And he couldn't afford it. He was homeless. So then, because he didn't pay, right? So he swipes a can of beer. He's charged, he's got all these court fines and fees, including this ankle monitor, which I think was $400 a month. He has no money. And he's homeless. At one point, he does get a place to live, but he still doesn't have money. He sells his plasma. That's his main. I think he had some Social Security income, and he sold his plasma. And he can't keep up with these payments. And because he can't keep up with the payment, he can't afford the court fines and fees. He is then sentenced to jail for a year. And so I did these stories in May of 2014. This was before Michael Brown dies in Ferguson in August of that year. there wasn't a lot of understanding in court fines and fees, but the Michael Brown's death sparked that in the area around St. Louis, where a lot of people were in Ferguson and a lot of those towns where police were making stops and charging people for small things. And if they didn't pay their fines, there'd be a warrant for their arrest. They created all this resentment against the police and created all this tension between police and citizens. So the point is that was a system. So I wrote about that in 2014, and that was another system where we don't put enough taxpayer money into making the system run well. So we have to find money, and the state legislatures do it by charging the people, the poorest people who go through the system, and basically criminalize poverty, create a cycle of poverty, a cycle of bad outcomes. Again, these are people who go through the criminal justice system, get fined, and when they don't pay, there's a warrant out for their arrest.
So you mentioned pretty early on in our conversation that the Biden administration's Children's Bureau has gotten into this since you guys reported. They took that where appropriate language, at least in the guidance that states have now, and sort of replaced that with almost like flipping it 180. So basically, the new kind of guidance to states is that this collection, at least as far as the feds are concerned, is not required, I think, except in very rare instances. And I'm not going to read the whole thing, but those rare instances are where I read it as the rare instances if a parent on some side of the child support is so wealthy that it wouldn't disrupt, attempts to reunify and things like that. So it's really flipped it on its head from the very poorest families being kind of the focal point to really maybe the only small number of wealthy people who are caught up in child welfare who do it. So anyway, that's executive branch action. I kicked off last year's podcast season with questions for 2022. And one of them I posed was whether Congress would take some interest in re-regulating. Now, you reported that there were some Democratic senators and Congress members who, had a bill on this, but were kind of shopping around for bipartisan support. Do you know, have you been in touch with them on that? Like any movement there, any green shoots for 2023 on this? What do you think?
They're still struggling. They're trying to find some good Republican co-sponsors, and that's been slow. So that's what it will take. As you said, the HHS put out its non-binding guidance. Some states, I know Washington State right away said they want to comply and change its practice. Washington State had already wanted to and was running into all these administrative and bureaucratic hurdles with the federal government. So Washington State has signed on. In California, there was a state rep, Isaac Bryan, who had some legislation passed that limits this in many cases. So I don't know how many states are going to eventually sign on. I know when I asked in North Carolina, I asked their reaction to what I found. The state Department of Health and Human Services said that they are trying to comply and they're looking at what they need to do to try to follow the new guidelines. So hopefully more states will sign on. But as you say, to really end it, we would need federal legislation, and Senator Wyden and Danny Davis and Chris Van Hollen from Maryland have this legislation out there that they want to do.
Yep. Well, I guess we'll see what 2023 brings on that count. NPR investigative reporter Joe Shapiro, thank you for joining us on the Imprint Weekly Podcast.
Thank you, John.
Thanks to NPR reporter Joe Shapiro for joining us today. The Imprint Weekly Podcast is a production of Fostering Media Connections, a California-based nonprofit that publishes the imprint Fostering Families Today and operates the Youth Voices Rising program. This podcast is produced and mixed by Christine Anjoko, with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we would greatly appreciate if you would consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, it's super easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle at The Imprint News and visit us on the web at imprintnews.org. You can always get us on email at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.